for these
Yep.
slides?
I think it's just forward. Yep.
Guess it is.
Oh, okay.
Okay. I'm very aware that we're the only thing standing between you and lunch in this beautiful city. So our goal is to be speedy, provocative, interesting, and at the end of the day, I hope useful. I started thinking about this presentation by looking at the fact that we're using the word transition multiple times. And what do we mean by that word? We got a definition from our host on the first day. You told us that we are all in transition. And I think that's fair enough. Over the past decade, we have seen the rise of economic analysis. We've seen a serious discussion on the meaning of abuse of dominance, the interaction between competition and trade policy, and whether or not non-economic considerations are appropriately recognized in competition law. And here I'm specifically thinking about the case of South Africa competition law, but it has broader implications. So we are all in transition. But beyond that, I think there are two special cases of transition economies. First are those emerging market economies that are transitioning from a command and control administered state to a privatized market sector. And second are those economies in undergoing transition in connection with EU accession. So there may be a certain amount of overlap, but these are special cases of transition. And the issues of concern are two. First is the law, the statutory language, getting the law right. And Doug and you have both addressed those. We can discuss those further later. The second issue is putting the law into operation, both by setting priorities in a system of strategic planning and by doing the work, effectively delivering the work product. So how do we bring this theory into practice? Well, I guess my first recommendation would be put Dag and Boris on speed dial and seek information and advice at all times. Beyond that, though, there are a variety of networks. They tend to be virtual. At least I think the most successful networks are virtual, informal, and cooperative. And these networks, and the one I'll talk about is the International Competition Network, can be of use to transition economies in doing their strategic planning and then bringing their plan into operation. But before I move on to some more slides, you wonder whether we can disagree. Let me tee up two issues that I was thinking about as Dag was talking. Where do you start as an agency, substantively, and where do you start as an agency procedurally? Your recommendation from the Commission is that cartels may be an appropriate place to begin enforcement. That's certainly not inappropriate, but an agency that is in an economy that is emerging from a system with a large number of state-owned enterprises, that may have been privatized into a single dominant player that then proceeds to abuse its position. That agency may hear calls from stakeholders to begin with dominance cases, even though they are complex and difficult, rather than cartel cases. Secondly, is enforcement the be-all and end-all of the agency's work product? I think we have to go beyond the numbers game, and the agency may consider enforcement important. It may also consider competition advocacy and building a competition culture to be a very important part of its role. So let me begin then with this network that may or may not be familiar. How many people have heard about or worked with the ICN? I think it's the sort of thing that operates at the edge of your vision because it is genuinely virtual. They meet in conference only once a year, but do a great deal of work online, through teleseminars, through other non-live occurrences. The ICN is quite different from other networks. Think about other networks that are playing in the competition field. The United Nations UNCTAD project comes to mind, as does the OECD. But ICN is really different. For starters, it is made up of competition agencies. This means it's at the agency level, not at the ministerial level. So it's possible for the agency heads and staff members to talk frankly about issues they confront. They are not speaking as ministers. In addition, it's all competition all the time. And beyond that, ICN members are broad. You think of OECD, the core membership is the developed countries. You think of UN, the core membership is the developing sphere. ICN crosses those boundaries. It includes all entities that wish to participate, developed and developing, and it seeks to involve stakeholders. ICN wants to reach out to economists, to lawyers, to firms, to academics if we're lucky to be invited. It's informal, it's based on consensus, and operates through specific projects rather than at a more high theoretical level. ICN has been quite a success. It made a standing leap in the past decade from 14 jurisdictions encompassing 16 agencies to most recently 99 member jurisdictions, including 112 agencies. And there's a lot of foment in the competition area. There are new competition regimes in Egypt, which is a member, and China, which is not a member of the ICN, and statutory and organizational reorganization in a variety of jurisdictions, as we've heard in the United Kingdom, Brazil, India, Mexico, Pakistan, and others. So the ICN is a site for discussing and maybe reaching consensus on competition issues. This is a picture of the ICN, of the jurisdictions with competition laws. It is not necessarily ICN members. You'll notice that China is colored red and China is not an ICN member. So if you look at the picture, what really stands out is the fairly overwhelming nature of competition law worldwide. Those little white spaces at the Canadian and American border are not jurisdictions that lack a law. Those are the Great Lakes. But the other non-colored in areas are those jurisdictions that have not yet adopted a law. And I think it's notable that the global south is still lagging behind in adopting competition regimes. Now, what does ICN do? First off, its program is convergence, not legal harmonization. It does not seek to enact a supranational enforcement agency. It is not in the business of writing uniform statutes. It seeks convergence where possible and principled divergence where convergence is not possible. And it covers the competition waterfront, law, economics, and policy. Its output is pretty vast. There is a large library of best practices, good practices, recommended practices, workbooks, toolkits, blogs. I'm not sure if it's on Twitter or Facebook. At my age, I hope not. And the newest project is the ICN University, which will be particular training modules available both online and by CD. ICN also offers in-person training and the opportunity to coordinate either by region or subject matter. Turning to what we're interested in today, ICN's current projects involve 3 matters of substantive enforcement: cartels, mergers, and unilateral conduct. competition advocacy, and finally, one important organizational question, agency effectiveness, and that's our subject today. The question of agency effectiveness involves planning, establishing priorities, implementing the law, and updating the plan as necessary. So what follows are the first two chapters from a toolkit that's being set up to give to agencies for their own application. And we begin with the question of strategic planning, and I would argue that strategic planning should be a matter of routine. It is not something that should be merely random. Strategic planning allows the agency to seize the initiative, because if you don't have a plan, the agency is merely reactive. The goal is to be thoughtfully proactive. The value of a strategic plan is first in its own right. It gives directive to the agency, but more than that, it brings in the stakeholders. And you're concerned about the stakeholders being ignored and not welcomed into the door. If stakeholders are part of the strategic planning process, this can encourage buy-in and build a general culture of competition. The point of a strategic plan is to begin broadly and identifying the objectives of the agency. This is especially important for